it please the court. Good morning, Your Honor. My name is Awang Mama Ridwan Binong Effendi. I'm the first counsel on behalf of the claimant, Ms. Jezeda. This claim is under Section 13(1) of the Sabah Labour Ordinance. The claimant submit that her dismissal was without just cause and excuse. Okay, the claimant served the respondent as a cashier for over 17 years with a clean employment record. In April 2022, the respondent directed her to transfer to Indrel Yawan College. This transfer involved not only a change of workplace but also a transfer to a different legal entity and change in position from cashier to general worker. The claimant objected the transfer as in substantially alter her terms and conditions of employment. She therefore declined the transfer and informed the respondent accordingly. Following her refusal, the respondent issued a show cause letter and subsequently terminate her employment. The claimant contended that the transfer was neither lawful nor reasonable. As such, her refusal did not amount to misconduct and that the dismissal was without just cause or excuse. The main issue before this Honorable Court is whether the respondent was entitled to dismiss the claimant for refusing the transfer. I now pass the submission to the next counsel. Thank you.
Your Honor, my name is Muhammad Hasan bin Ali Basri. I am second counsel appearing on behalf of the claimant Jezida. So, the question to be I answer is since the offer letter was specifically with Jom Lepak SDN Batch D, can the employer legally loan or give her to a completely different company without her sign a new agreement? My lord, the claimant respectfully submit that the respondent had no legal authority to transfer her employment from Jom Lepak SDN Batch D to Indrel Yarwan College without her consent. Firstly, the claimant employment contract was specifically with Jom Lepak SDN Batch D. The offer letter clearly identify that company as her employer. The claimant never signed any contract with Indrel Yarwan College. Secondly, Jom Lepak SDN Batch D and Indrel Yarwan College are separate legal entities. Even if both belong to the same corporate group. Each company has its own legal identity. Therefore, the transfer was not merely an internal reassignment, but a transfer to a completely different employer. My lord, while the respondent relies on managerial prerogative, such prerogative is not unlimited. An employer may manage its workforce, but it cannot unilaterally change a fundamental term of the contract, namely the identity of the employer. Finally, the claimants refuse to accept the transfer cannot amount to misconduct. An employer is entitled to reject an unlawful instruction and insert on the terms of her existing contract. Accordingly, the claimant respectfully submit that the proposed transfer was invalid and unlawful, and any discipline action arising from her refusal should not be sustained. Those my submission, my lord.
May it please the court. Good morning, Your Honor. I appear on behalf of the claimant to address the second issue, whether an employer may change Jezida specialized role as a cashier into a manual labor without her consent. The claimant submits that such a change is not permissible because it fundamentally alters the nature of her employment. Jezida served as a cashier for over 17 years, handling payments and customer transactions. Directing her to work as a general laborer introduced duties outside her established scope. An employment contract rests on mutual agreement. Significant changes to an employer's role require consent, while operational challenges during the pandemic are acknowledged, they do not justify unilateral removal from a specialized position. Therefore, the claimant contends the employer had no rights to impose this change, and Jezida refusal was reasonable. The instruction exceeded her original employment terms. That is all from me, Your Honor. Thank you.
I am a counsel for the claimant. I will address issue 3, which is whether section 11 subsection 3 subsection E of the Sabah Labour Ordinance protect an employee who refuses a transfer when the employment contract does not contain a transfer clause. My Lord, the claimant submit that the answer is yes. First, there is no transfer clause in the claimant employment contract. The contract does not state that she must accept a transfer to another company or another position. Second, an employee has the right to rally off the term employment contract. If the contract does not require the employee to accept a transfer, the employer cannot force the employee to do so. Third, the claimant refusal should not be treated as misconduct or insubordination. She was only exercising her contractual right. In this case, the transfer involved a different company and different role. Therefore, it was a significant change to her employment and required her consent. In conclusion, the claimant was not legally required to accept the transfer. Her refusal was lawful and her dismissal was without just cause and excuse.
May it please the court. Good morning. My name is Fralisa Farinantian. I appear on behalf of the claimant, Ms. Jezida. My lord, we are here today to determine whether the respondent could lawfully transfer my client, who worked as a cashier for 17 years, to a different company as a manual labor without her consent. My lord, as we conclude this matter, the claimant respectfully maintains that her dismissal was a grave injustice carried out without just cause or excuse. For over 17 years, Ms. Jezida served Jomlei Park faithfully as a cashier. Yet, in April 2022, the respondent attempted to unilaterally transfer her to a completely separate legal entity, Idril Yarwan College, and force her into a manual labor role as a general worker. The respondent relies heavily on managerial prerogative and the pressures of the pandemic. However, the managerial prerogative is not an absolute right, and it cannot be used to override an employee's contractual protection. Her contract was with Jomlei Park and not with a sister company, and she never consents to this change. Furthermore, under Section 11E of the Sabah Labor Ordinance, since her contract contained no express term requiring her to accept such a transfer, she was legally entitled to refuse. The word "not" written on the transfer letter was not an act of insubordination or an intention to abandon her career. It was a lawful expression of disagreement with a fundamental breach of her contract, a breach that amounts to constructive dismissal. 17 years of loyalty should not be met with a demotion to a manual labor under the guise of operational necessity. Therefore, we pray for this honorable court to find the dismissal unlawful and grant the following remedies: reinstatement to her original position as a cashier, or in the alternative, compensation equivalent to 17 years' month's salary, representing 1 month for every years of her dedicated service, along with back wages, unless I can be of further assistance to the court. Those are our submissions, my lord.
May it please the court, my name is Syaris Atami bin Suprin, appearing as Counsel 1 for the respondent Jomlei Park Sendirian Berhad. The issue before this honorable court is whether HR should be allowed to transfer employees between sister companies during a crisis to avoid termination. The respondent respectfully submits that the answer is yes. Your Honor, during extraordinary circumstances such as the COVID-19 pandemic, employees face severe operational and financial challenges. In such situations, HR should be permitted to transfer employees between sister companies where the purpose is to preserve employment rather than terminate it. In the present case, the respondent did not immediately dismiss the claimant when the cafe was unable to operate. Instead, the respondent offered her an alternative position within another company in the same corporate group. This demonstrates that the respondent's primary intention was to preserve the claimant's employment and provide her with continued work during an unprecedented crisis. Allowing such transfers also benefits employees, as it enables them to retain their employment, continue earning an income, and avoid retrenchment during difficult economic conditions. At the same time, it allows employees to respond effectively to operational needs while maintaining business continuity. Therefore, the respondent respectfully submits that HR should be allowed to transfer employees between sister companies during exceptional circumstances where the transfer is made in good faith, based on genuine operational necessity and with objective of preserving employment rather than terminating it. Those are my submissions on this issue. Your Honor, much obliged.
May it please the court. Good morning, Your Honor. My name is Nur Afifah Shazina binti Rizal. I am a second counsel appearing on behalf of the respondent Jomli Park Sendirian Berhad. The respondent respectfully submits that a managerial process and imply an inherent authority to reorganize the workforce as part of the well-established principle of managerial prerogative. This authority is essential to ensure the continued efficiency, sustainability, and viability of the business. Firstly, managerial prerogative grants employers the right to direct, control, and organize their workforce. These include decisions relating to restructuring departments, reallocating duties, and adjusting reporting lines when necessary. Such authority does not need to be expressly stated in every detail of an employee handbook because employment relationships are governed not only by express terms but also by implied terms that allow business to function effectively. Secondly, employer handbooks are not exhaustive documents. It is impossible for any handbook to anticipate every operational challenge or future business need. Therefore, the absence of a specific provisions authorizing workforce reorganizations does not mean that the employer lacks such authority. As long as the decisions does not contradict any express contractual term, the employer may rely on its implied power to manage the reorganization effectively. Thirdly, business survival and operational necessity provide strong justification for restructuring. In today's competitive, the rapidly changing economic environment, employer must have the flexibility to respond to financial pressure, technological change, and market demands. Finally, while managerial prerogative is broad, it is not unlimited. The employer must exercise this power reasonable, fairly, and good faith. In the present case, the restructuring was undertaken for genuine operational reasons and not for any arbitrary, discriminatory, or malicious purpose. Therefore, the respondent respectfully submit that the managed act within the scope of lawful managerial prerogative, and the restructuring decision should be upheld by the Honorable Court.
May it please the court. Good morning, Your Honors. My name is Muhammad Ikwan bin Rosli, and I am a third counsel appearing for the respondent, Jom Lepak Sindran Berhad. The respondent says the dismissal was lawful because the claimant refused to follow a reasonable instruction, which is misconduct. The claimant worked as a cashier for about 17 years. During COVID-19, the business was badly affected and there was a less need for cashier work. To keep her employed, the claimant was moved to the role of general worker. She was not dismissed at that time. She was still offered a job in the company, but she refused to come to work and refused the new duties. An employee must follow lawful and reasonable instruction from the employers. Employers also have the right to organize work, especially when business conditions change, like during the pandemic. The instruction given was reasonable and made in good faith. It, it did not end her employment or break her contract. It was part of managing the business during difficult times. The claimant refused without a valid reason. This is disobedience and a breach of her duty as an employee. Therefore, the respondent says the dismissal was justified and the employee did nothing wrong. For this reason, the claimant claim should be dismissed. May it please the court.
Good morning, Your Honor. My name is Muhammad Hazim bin Muhammad Azlan. I'm a fourth counsel appearing on behalf of the respondent, Jam Lepak Esten BHD. On issue 4, the respondent submit that the claimant committed insubordination and technically abandoned her employment. First, writing not clear. Insubordination, the claimant wrote the word not on the respondent's transfer letter. That was not just a note, but a clear rejection of a lawful management instruction. Under the contract of employment, an employer must obey reasonable instruction from the employer. A written refusal like this already fulfills the element of insubordination, failure to attend abandonment of employment. After the instruction was given, the claimant was directed to report at Indrel Year 1 College as the general worker. The claimant did not attend at all and gave no reasonable excuse. When an employer deliberately fails to attend after a clear instruction, the law treats it as abandonment of employment. The claimant herself terminated the contract through her conduct. Your Honor, not show intent to disobey, not intending show the claimant abandoned her contractual duties. Therefore, the respondent submit that the claimant committed insubordination and technically abandoned her job. The dismissal was lawful and proportional to the offence. That conclude our submission. Your Honor, thank you.
May it please the court, good morning. My name is Asrina binti Herman. I am the co-counsel of the behalf of respondent Jom Lepak Sundan Berhad. May it please this honorable court. The respondent respectfully submit the claimant's dismissal was with just cause and excuse. The evidence before this court demonstrates that the respondent acted reasonably, responsibly, and in good faith during the unprecedented challenges brought about the COVID-19 pandemic. But with the closure of its cafe operation and the lack of available work in the claimant's original positions, the respondent chose not to terminate her employment. Instead, it sought to preserve her livelihood by offering her alternative role within the same corporate group. Transfer was not punitive, arbitrary, or motivated by bad faith. It was implemented solely to ensure business continuity and avoid retrenchment during a period of severe economic uncertainty. Such a decision was reported with the respondent managerial prerogative to organize and deploy its workforce according to genuine operational needs. The instruction given to the claimant was lawful and reasonable. However, rather than complying with that instruction, the claimant expressly rejected it by writing note on the transfer letter and thereafter failed to report for duty. This conduct amounted to a clear refusal to obey a lawful management directive and constitutes serious insubordination. Importantly, the respondent afforded to the claimant an opportunity to explain her actions through the proper disciplinary process. Despite this opportunity, no reasonable justification was provided for her refusal to perform the alternative duties assigned to her. In the circumstances, the respondent then submit that the dismissal was not harsh, or unreasonable. It was a proportionate response to the claimant's persistent refusal to comply with lawful and reasonable instructions.